Okay, this is Walton et al. Versus Ansel, docket number Jackson County docket number 20-2263 CB. I'm sitting by assignment of the State Court Administrative Office, and this is the time set for a hearing on the defendant's motion to set aside default and the plaintiff's motion for entry of default judgment. And first, before we go on, I'll take the appearances of counsel for the record.
Thank you, Your Honor. Bruce Inocencio on behalf of the plaintiffs. Good afternoon.
Hello.
Good afternoon, Your Honor. Alexander A.R. on behalf of defendant Brandon Ansel, who's also accompanying me, Your Honor.
Good afternoon, Your Honor. Rebecca McCluskey, co-counsel for Mr. Ansel.
Okay, I was hoping that we could just do these together as one, as like your motion, Mr. Ayer, for motion to set aside default. We'll just call it that and cover everything in that argument that pertains to both motions.
Sure. Thank you, Your Honor. In this matter, plaintiff's attorney emailed defendant's attorney a copy of the complaint, but did not provide a full, complete set of the exhibits that were referenced and attached to the complaint. Specifically, exhibits 3 and 4 to plaintiff's complaint was never served upon us. In fact, Your Honor, we still have not received the affidavit of Mr. Markin, which was purportedly attached to the complaint. The affidavit of Mr. Markin that was attached to his response to my motion was just signed this week, 2 days ago. And so we still don't have Mr. Markin's affidavit that was appended to his complaint that was filed several months ago. At plaintiff's request and as a professional courtesy, Ms. McCluskey executed an acknowledgement that was prepared by plaintiff's counsel that did not identify any exhibits and only stated that she acknowledged receipt of copies of the summons, complaint, and assignment, which is expressly different than the SCAO form, which acknowledges service, which I'll get into later. Because Ms. McCluskey is a solo practitioner that does not practice in the areas of law that the claims alleged in this action, as well as defendant's counterclaims, defendant was forced to move quickly to secure additional counsel during the COVID-19 pandemic. Ultimately, Ms. McCluskey personally contacted plaintiff's counsel before the expiration of the 21-day time period with which when defendant's answer and affirmed defenses and counterclaim were required to be filed. Ms. McCluskey, in that telephone conversation, again, before the 21-day deadline expired, she kindly explained to him the reasonable delay and requested a professional courtesy of a brief extension of time for defendant to answer or otherwise respond in accordance with the Michigan court rules, which is done all the time and is granted all the time. In response, plaintiff stated that he would ask his client and circle back, but plaintiff's counsel never circled back. Instead, plaintiff's counsel, unbeknownst to Ms. McCluskey, defendant's only attorney at the time, wrongfully signed his own default and filed it with the court on the very first day plaintiff's counsel wrongly believed he could do so. This was about 2 weeks ago, Your Honor. To date, no default was signed by the court clerk. Plaintiffs have not alleged any prejudice to 1-day delay in answering. The precedent that only a court clerk can enter a default it's overwhelming. Specifically, Your Honor, the SCAO form expressly states that the clerk, which is attached to Exhibit L of my motion, it only references the clerk that can sign the default. It doesn't allow plaintiff to sign the default. He has no authority to do it. Additionally, Your Honor, in ISB Sales Co. versus Dave's Cake, which both plaintiffs and defendant rely upon, it expressly states in that opinion, the entry of default was signed by the deputy clerk. That's at 525 of that opinion. The Michigan Court Rules practice, which many published opinions rely upon, including the ISB case, which I just referred to, relies on the Michigan Court Rules practice. That treatise also states that the default must be signed by the clerk of the court. In In re forfeiture case, which is also referenced in our motion, it states that the entry of default is not automatic. Rather, the facts justifying entry of default must be made known to the clerk of the court. Your Honor, defendant contends that the court should rule that there is no default entered. However, if the court finds that a default was entered, there clearly is good cause and numerous meritorious defenses to set us aside. For a good cause, Your Honor, we need substantial defect or irregularities in the proceeding or a reasonable excuse. Well, defendant has all three. First, defendant clearly has a reasonable excuse in light of the difficulties obtaining co-counsel and the facts that plaintiff's counsel told Ms. McCloskey that he'd be circling back, but never did, instead filing a default right from under her nose that he signed himself. We were never served properly with the complaint because we still to date have not received all the exhibits that were referenced and attached to the complaint. Plaintiffs admit in their response that defendant was not served with all their exhibits to the complaint. As I mentioned earlier, specifically Exhibit 4, the purported affidavit of Mr. Markin, which is attached to the response, was just signed on Monday of this week. Well, how could it have been signed on Monday of this week if they attached to the complaint filed months ago? It couldn't have. We still to this date have not received Mr. Markin's affidavit that plaintiffs attached and referenced to their complaint. Mr. Markin's affidavit also should not even be considered because it violates Michigan Court Rule 2.119B because it's not based on his personal knowledge and it's peppered with hearsay and other inadmissible evidence in violation of the court rule. For example, paragraphs 8, 9, and 10 are all qualified by saying Mr. Markin was informed and believed. Well, that's hearsay and it's improper to the court rules. The affidavit must be based on personal knowledge, and Mr. Markin's affidavit clearly is not based on personal knowledge. It is not based on facts and municipal evidence. The alleged affidavit of Mr. Markin also fails to comply with the Michigan Court rules for several different reasons, including paragraphs 7, 11, and 12, also are not based on personal knowledge, also contain numerous hearsay and should not be considered. In addition, Your Honor, because neither Ms. McCloskey, defendant's sole attorney at the time, and defendant were never provided with a complete set of exhibits, well, defendant was never properly served with a copy of the complete copy of the complaint. We all know that Michigan Court Rule 2.113C2 states that an attachment is part of a pleading for all purposes. Michigan case law also echoes that and states that a contract attached to a pleading is considered part of the pleading. The term pleading is defined by the court rules as a complaint. And because the full and complete complaint was not ever served upon us, because the exhibits were never there, we were never properly served. Plaintiff's notice of entry default only identifies a summons, complaint, and assignment, but fails to identify any of the exhibits referenced in the complaint. Failing to properly serve defendant with a complete copy of the complaint constitutes a substantial defect or irregularities in the proceeding upon which the default was based, as well as a defect in the process and notice, thereby establishing good cause to set aside the purported default. Also, Your Honor, the acknowledgement of receipt drafted by plaintiff's counsel, and that's important, Your Honor, because they didn't use the SAO form summons to acknowledge service. He prepared his own document, which doesn't even identify service. It just says acknowledges receipt. So again, we were never served with a complaint. I reference SCAO form MC01, the summons, which expressly uses the language received service. However, the document that plaintiffs prepared doesn't even mention the word service. It just says acknowledges receipt. And Michigan case law is clear that there's a difference between receiving a pleading and acknowledging receipt of the pleading. I reference Holliday versus Townley for that proposition. Also, because plaintiffs drafted that acknowledgement, it should be construed against him under the Clapper v. United Insurance, which is Michigan Supreme Court case. Obviously, Your Honor, there has not been any default entered or signed by the clerk, as I discussed earlier. Also, due to the ongoing settlement negotiations, which again, plaintiffs acknowledged in their response, Ms. McCloskey being a solo practitioner, immediately reaching out for co-counsel, requesting for an extension, plaintiff's counsel saying he's going to circle back, but instead the next day filing a purported default with the clerk that he signed himself also provides with a reasonable excuse. Also, Your Honor, we're talking about a significant dollar figure that the plaintiffs are seeking. They're asking this court to enter a judgment of over $2.5 million. Again, the significant size of the default judgment also weighs in favor of finding good cause and setting aside the default. Also, Your Honor, you can consider whether or not we defendant completely failed to respond or simply missed a deadline. Well, we have filed and the court clerk has accepted our answer, affirmative defenses, and our counterclaim, which are appended to the affidavit of meritorious defense, which is over 80 paragraphs long, 17 pages, attaches and references multiple emails of investors of PitchMe, which completely absolve defendant of any wrongdoing whatsoever. There can be no reasonable debate that the good cause has been established to set aside the default. Equally, defendant has established a meritorious defense to set aside the default, Your Honor. At the outset, there is issues with subject matter jurisdiction with this court, as we pointed out in our filings. There are at least 8 plaintiffs who have an amount in controversy that does not exceed the $25,000 figure.
Your Honor, I'm going to object at this point. If I may just briefly object, because the issue that we're dealing with at this point, Your Honor, is beyond the scope. And I know that the court said I'd like to address both of these issues at the same time. And I understand that. However, I would note that the motion to set aside the default did not include any argument whatsoever regarding subject matter jurisdiction. So for that,
his response to your motion for default judgment did.
That's correct. I'm just placing that on the record.
Go ahead, Mr. Ayler.
Thank you, Your Honor. Specifically, Your Honor, the district court has exclusive jurisdiction in all civil actions when an amount in controversy does not exceed $25,000. Well, at least 8 named plaintiffs, their investment was $25,000 or less, and that's supported by the affidavit of Mr. Ansell, which we appended to the filings of this court. They filed, to the extent they have a claim, they're in the wrong court. They should have filed in district court. In addition, Your Honor, the affidavit of meritorious defense, which I alluded to earlier, sets forth the reason why the investors lost their investment. It was not because of anything Mr. Ansell did. It's because lead plaintiff, Mr. Walton, failed to conform to his affirmative obligations to invest money in the business, therefore leading it to its demise. Mr. Ansell, who invested over $150,000 of his personal money into PitchMe, devoted over 3 years of his life without any pay or benefits from PitchMe, suffered also due to Mr. Walton's action, which is part of the basis of our counterclaim that we've already filed and asserted against him. The affidavit goes on to articulate that plaintiffs are accredited investors, all of whom were well aware that any contribution being made was high risk, a high risk startup endeavor, and it was highly likely that they would lose their investment. In Mr. Ansell's affidavit, he clearly says that before any investment was made, all the investors knew that because he told them. And to the extent Mr. Walton or Mr. Markman solicited investors, Mr. Ansell's affidavit states that he specifically told Mr. Walton and Mr. Markman to tell any prospective investors that well before any contributions were made, that this is a high risk technology startup and they would likely lose their entire investment. Everyone knew that. And Judge, it's not just Mr. Ansell's affidavit that says that. Other investors sent emails to Mr. Ansell, which we attached to his affidavit, which they all speak in one voice, that they all knew that this was a high risk startup. They all knew that they were probably going to lose their money. They all stated that they were well informed of the ongoings of the business, that they had regular meetings, that there was regular information provided to them, that there was open door policy, that Mr. Ansel answered their phone calls, and it goes on and on, Your Honor. It's 83 paragraphs, and I won't belabor with all the paragraphs, but it certainly establishes multiple meritorious and absolute defenses, which is satisfied to set aside a default. Your Honor, also we have legal arguments which are identified in our affirmative defenses, which we also attach to Mr. Ansel's affidavit. Those affirmative defenses include that the breach of fiduciary duty claim is right for summary disposition under the business judgment rule. That is fully briefed in our pleadings as well. The breach of fiduciary claim is also right for summary disposition because of PitchMe's restated articles, which state in relevant part, monetary liability of a manager to its members for breach of any duty shall be eliminated. Those are in its articles. Those are filed publicly. In fact, it was appended to plaintiff's complaint. The breach of fiduciary duty claim is also right for summary disposition for the independent reason that the expiration of its relevant 3-year statute of limitations. That legal defense is also fully briefed. The purported fraud claim is also right for summary disposition because none of the 34 plaintiffs alleged with sufficient particularity their purported fraud claim, which is required under Michigan Court Rule 112B1, as well as Michigan law. A plaintiff's purported accounting claim is also subject to summary disposition because plaintiffs were required to request their accounting in writing. And Michigan Compliant Law 450.2487 states that, and we referenced that in our brief. There was never any written request, and plaintiffs did not attach any written request to their complaint, which they were also required to do under Michigan Code Rule 2.1131. Plaintiffs also fail to state a claim under the Michigan Uniform Security Act. That's also fully briefed in our pleadings and our filings with the court. Many of the plaintiffs were actually not members of PitchMe LLC. They're actually members of another entity. Therefore, they lack standing to pursue any claims alleged in the complaint. Also, Your Honor, each of plaintiffs' claim rely on PitchMe's operating agreement, which was again never appended to the complaint. And I know that plaintiff's counsel in his brief says, well, you already have it. Well, we need to make sure what they attach to the complaint is actually the operating agreement. That's the whole point of due process, so that we can challenge anything that he appended, which maybe wasn't the operating agreement. We don't know what he attached because he didn't attach it. He also didn't attach the affidavit of Mr. Markman, which all the accounts rely on to assert their claims. In fact, we still don't have it. The only affidavit we have is one that was signed just 2 days ago. In response to the, in further response of the plaintiff's motion for entry of a default judgment, Your Honor, under Michigan Code Rule 2.603B3B, in order for a court to enter a default judgment or to carry it to effect, it is necessary to take into account, determine the amount of damages, establish the truth of an allegation by evidence, or otherwise investigate any other matter. The court may conduct hearings and could do what is necessary and proper and shall accord a right of a trial by jury to the parties. Your Honor, there was no evidence whatsoever to establish a judgment of over $2.5 million for 34 plaintiffs. It's a very unsupported motion. There's scant allegations. There's not even a brief in support that was filed, which is required by Michigan Code Rule 2.119A2. Says you need a brief in support. They didn't even include the brief in support. It was a very scant motion, which there does not verify any way whatsoever any of the purported damages. And you know, we probably know why. Is because at least 8 of the plaintiffs that we know of don't even meet the subject matter jurisdiction threshold to even be in this court in the first place. Again, Your Honor, it's plaintiffs' affirmative obligation to provide this evidence to the court so that the court can determine the amount of damage, establish the truth of by the evidence. We did demand a jury trial if it gets to that point, Your Honor, but we don't believe it should. We believe that the court should rule that a default was required to be signed by the clerk as the SCAO form requires, as the Michigan case law requires, plaintiffs provided no authority whatsoever that he is allowed to sign his own default and file it with the court. The register of actions should not be relied upon because he conflates filing a default with entering a default. We all know that when the court enters an order, it signs the order. When the clerk enters a default, it signs the default. That's the mechanism by which it is entered. Again, Your Honor, a plaintiff's motion for entry of default judgment, paragraph 3 states that it attached exhibit 2, 3, and 4 to the motion. However, I never received, Ms. McCloskey never received, defendant certainly hasn't received any of those exhibits that he references in his paragraph 3. We don't have exhibit 2 or exhibit 3 or exhibit 4. We only have one exhibit. And again, that's a fundamental breach of due process, which appears there's a habit here of plaintiffs referencing exhibits but not serving exhibits on the opposing party. Plaintiffs did not verify their alleged motion, nor did they properly verify their complaint. The complaint only alleges to be verified by Mr. Walton. However, even the purported verification of Mr. Walton fails to comport with the court rules, specifically Michigan Rule 1.109D3. It completely fails to satisfy those requirements. The default judgment is also wrong when it states, and I'll quote, the legal time for filing and serving an answer or otherwise defending expired on November 10th, 2020. Well, that's not true. That was actually within the 21-day time period where Ms. McCloskey asked for an extension, where plaintiff said, well, I'll circle back with you. Let me check with my client, but then signed his own default and tried to file it underneath her notes. So for all those reasons, Your Honor, we respectfully request that you grant defendant's motion to set aside the default and deny plaintiff's motion for entry of a default judgment.
Mr. Inocencio?
Thank you, Your Honor. A couple points, and my experience with this court, Your Honor, is that the court has reviewed all the pleadings, and I'm assuming that has happened in this case. And so I don't think I'm going to waste everyone's time regurgitating all of the arguments that we've made in the documents. But I will say this, with respect to the court rules are clear, and they speak for themselves. And for example, when we're talking about requiring a plaintiff who has yet to receive a response from the defendant to file a brief attached to a motion for entry of a default judgment, the court rule only requires a motion to be accompanied by a brief when there is an issue of law. That's what the court rule says. And if we look at the defendant's pleadings, their argument, they're misstating by lack of a complete statement of the court rule what the court rule requires. And that's important. That's the same approach that they've taken relative to this claim that somehow, because I signed the default and tendered it to the court, that is in violation of the court rule. Your Honor, the court rule is clear. When you are looking to have a default judgment entered, the court clerk must sign and enter. That is a court rule requirement, no doubt about it. But that signature requirement is not found in the court rule as it relates to entry of a default. It's simply not there. And it is commonly done throughout the state of Michigan to have attorneys tender a default document that they've signed that puts the court clerk on notice that there has been a passage of 21 days, there's been no timely response, and it's time to enter the default. And the attorney prepares that and or signs it. If the Supreme Court of this state wanted to say that attorneys are not permitted to sign defaults, that they must only be signed by the clerk, that requirement would be in the court rule. It's simply not there. And it's frustrating that defense counsel has attempted to include that in here to confuse the issues. It's simply not in the court rule. Looking at the specific requirements in the court rule relative to good cause and the affidavit of meritorious defenses requirement. Your Honor, this is a situation where we fully acknowledge that exhibits 3 and 4 were, for some reason, and I take full responsibility for it, Your Honor. It's my case, it's my file. I don't know why exhibits 3 and 4 were not attached to the complaint at the time of the filing, nor do I know why they were not served upon Ms. McCluskey after we talked on the phone and she agreed to accept service. But that happened. There's no doubt about it. So if this court feels that that's good cause, then we have to live with that decision and we recognize it. But here's what I want the court to consider. I sent those documents to Ms. McCluskey the very next day. No action was taken for 3 weeks. Now, the defendant now wants to argue that it was an acknowledgement of receipt as opposed to an acknowledgement of service. And here's what frustrates me, Your Honor. If the court looks at Exhibit F to the defendant's motion, the court will note that it's a one-page document. It's the signature page that Ms. McCluskey signed. Now, if the court looks at our Exhibit 7, that's a 2-page document. And it's the second page of the acknowledgement of service. And it's the first page. It doesn't say acknowledgement of receipt in the caption. It says acknowledgement of service. Now, she can say all day long that she wasn't served. However, I sent those documents, and on the 20th day after having sent those to her, then she crosses off the date twice and sends them back to me and says, oh, okay, I misplaced this. It's actually October 20th that I'm going to acknowledge receipt. So they've already had 20 days at this point. Nothing was said to me at all. They just laid back silently. Nothing was said to me about saying, hey, I didn't get Exhibit 3 or 4. Could you send those to me? We would have done it. If she had brought that to my attention, we certainly would have done that. Now, let's look at those exhibits. One of them is the operating agreement. Mr. Ansel signed the operating agreement twice on the last page. Once in his capacity as the manager, once in his capacity as a member. There's only 3 members. If for some reason they believe that there's a different operating agreement floating around out there, Mr. Ansel would know that. He was in charge of this entity from the beginning. This entity has always been represented until February of this year by Patrick Chagru. Mr. Chagru had a copy of the operating agreement. I contacted Mr. Chagru Friday after I received the motion late Wednesday afternoon, right before Thanksgiving, and I tracked him down. Fortunately, he spoke with me for about an hour. And I said, has there ever been another operating agreement? Has it ever been amended or restated? No, not that I'm aware of. I said, okay, will you please send a copy of that to Rebecca and to me so that we both have the same copy, just to make sure. Your Honor, there's only one operating agreement. This is the same operating agreement that they're basing part of their counterclaim on. So to suggest that they've never been provided with it or received it is somewhat disingenuous when you take into consideration Mr. Ansel is the manager of this entity. He signed the last page twice. He knows that the operating agreement has never been amended or restated. So there's nothing here to hide the ball. This wasn't some type of a nefarious tactic. Relative to Mr. Markin, the reason he just signed the affidavit the other day is because when he sent it to me when his attorney sent it to me, I forwarded on to Ms. McCluskey via email 12 days before we went to mediation. It's the same. The only difference is it's been signed, and I contacted his attorney and said, hey, the one you sent me isn't signed. I need you to get his signature. He didn't backdate it. Mr. Markin drove to his attorney's office on Monday, signed it. They sent it to me. I've since sent it on now. It's the same affidavit. So again, these documents were in the possession of the defendant or the defendant's counsel back in July. This is not something where we just now are coming up with these documents. They've had them. And if they didn't have them, they could have contacted me and I would have provided it. But to argue that this is somehow a denial of due process is somewhat disingenuous. Your Honor, with respect to the good cause requirement, it's important to note and I know this court knows this, but I want to make sure I state this on the record. There has to be a substantial defect, something of substance. What's the complaint in the procedural irregularity? Well, there's two things. One, I signed the default. Well, they're relying on an argument relative to a court rule that doesn't include the requirement they want this court to impose. Frankly, they should be sanctioned for that. I don't say that lightly, but when you come into court and you argue that a court rule requires something that it does not require, that's sanctionable. That position is not warranted by existing law, and it is not well-grounded in fact. That's problematic, and we need to stop it. We need to stop it now. To suggest that we somehow entered a default that we shouldn't have entered because I didn't follow the SCAO form, that's also disingenuous. There's no requirement that a default is entered via an SCAO form. All it has to have is the language that's required by the court rule. It has that. And I signed it, and the clerk entered it. I don't know why the clerk allowed the counterclaim and answer and affirmative defenses to be filed and entered. It should not have happened. I can't stop that. I can only ask this court to take a look at that and say, okay, what's the practice here? Why was this allowed to be filed when a default was already in the record? That happened. And so I don't think that should be held against the plaintiffs in this situation. Relative to all of the rationale that's included for good cause in the defendant's motion, I would just say this. None of those issues rise to the level of a substantial defect. And you don't just have to have good cause, you also have to have an affidavit of meritorious defenses. So let's talk about that briefly. Mr. Ansell's affidavit does not include evidence. You can't just say, here's an affidavit. You can't just say it has meritorious defenses. It has to be substantive. You have to have facts and evidence. You can't just make these conclusory allegations or statements. I didn't breach any duty. I didn't do this. I didn't do that. Where is the proof? Now, interestingly, in this case, we can go one step further and we can look at the actual answer that shouldn't have been filed, but was. If the court looks at our complaint right next to the answer and aligns all of these, it's interesting. If you look at the various causes of action, as you get toward the end of the cause of action, all of the responses are blanket denials without any substance. It's just the defendant denies as untrue. The defendant denies as untrue over and over and over again, 49 times. That's insufficient. That's not the appropriate standard. You have to come into court and say, here is the substance upon which we will rely. And to sit here and say, hey, there's a $2.5 million judgment against me potentially. I've had 6 weeks to respond to it between September 30th or October 20th, if we take that as the day. And now here we are, late November, early December, and we don't have substantial denials. This is not a situation where this lawsuit was sprung upon Mr. Ansell or his counsel. I attached Ms. McCluskey's email that was sent July 21, 2020, after pre-litigation mediation failed. And she says, we're ready to proceed. We've known about this threatened litigation for a long time. We don't think there's anything here. Well, then why has it taken so long to get a response? What is happening here? Your Honor, this is the pattern that my clients have been dealing with for Mr. Ansell since the beginning of this entity. And it is somewhat suspect to say that Mr. Ansell was somehow able to convince all of these investors to invest a couple $1 million, all while telling them it is highly likely you will lose your entire investment. He wants this court to believe he told all of these investors it is highly likely you're going to lose 25 grand, 50 grand, 100 grand, but do it anyway. Your Honor, I know this court does not take lightly this decision. This is an abuse of discretion, standard. And I would just ask that the court seriously consider the delay that we've been faced with, the appropriate standard. I would also ask that the court, if the court does decide today, either way, what the court decides, I think it's appropriate to award sanctions in this situation. Your Honor, I received this motion exactly 1 week ago today, approximately 4 p.m. the day before Thanksgiving. And I spent 30.9 hours over Thanksgiving weekend working on a response because obviously I'm without support staff over the holiday weekend, and I had an obligation to get an answer into the court on Friday. I couldn't do that. I tried, but the court was closed, both in Jackson and Ingham County. So I had to file it Monday, the first possible day. But it's unbelievable to me that when I file a motion back on November 12th to be heard today, they've had 3 weeks to put together a motion to set aside the default, that they wait until the very last possible minute so that I end up having to work on this and track down all of my clients over the holiday weekend to try and figure out how we should appropriately respond to this. Thank you, Your Honor.
You don't like that jurisdiction argument, do you?
Well, Your Honor, I think, here's what I think about the jurisdiction argument. I think that, number one, it's not timely raised. I mean, their response to my motion was due last week. I got it. Honestly, here's what happened. I drove up to Lansing on Monday to file my response, to hand deliver it, to get it there on time. And when I got back to my office, there was a copy of theirs in the door here at my office. Here's how I look at the jurisdiction issue. All of these individuals were through this entity called Pitch Me Investors, LLC, but they were all individually solicited. I don't see it as a jurisdiction issue. And I think if you have a jurisdiction issue, you raise it in the motion to set aside the default.
Well, wait a minute, but jurisdiction for as to Mr. Walton comes through the Limited Liability Company Act, doesn't it?
Right, they're not claiming that. I don't think that that's what they're claiming.
Your Honor, lack of subject matter jurisdiction can be raised anytime.
Yeah, no, I don't butt in until I ask you to.
Sorry, Your Honor.
Mr. Inocencio, so Mr. Walton's claims would fall under the Limited Liability Company Act, correct?
In part, yes, they would, Your Honor.
Okay. The other plaintiffs are investors, correct? I think you're frozen. But he really doesn't like this issue. He froze up on me.
Your Honor, I'm here, Your Honor.
You froze up on me.
Well,
Again. Okay, Mr. Inocencio, I don't know if you can hear me, but you have frozen up again. You must greatly fear me to freeze up every time I speak.
I heard you where you're going with this, Your Honor.
Yeah, you were frozen for a long time there.
Okay, yeah, I'm not sure, and that's when I was making my best argument too. So,
Yeah.
So go ahead with your question because I want to make sure I heard the question and I give you a response.
Okay, so Mr. Walton's claims would fall under the Michigan Limited Liability Company Act, would they not?
They would in part, that's correct.
And then the other plaintiffs are investors, right?
Yes.
Well, I mean, even if they had under $25,000 claims, wouldn't they, I mean, isn't there an argument that they get joined with Mr. Walton's claims anyway?
Yes, Your Honor. The problem is I didn't get that response to even respond to until Monday at 4 o'clock. That argument wasn't made for me to brief. That's the problem. That's why I kind of objected to it, because had I known that was the argument, I would have addressed it in one of my responsive documents.
I get it. All right. So Mr. Ayer, go ahead.
I do think there's a
Oh,
joint.
sorry.
I do think there's a joinder issue, and frankly, all of these individuals were at least the $25,000 mark. Okay, so if they were at $25,000 and they tendered their shares back pursuant to the process referenced in the complaint, and they were allowed to calculate interest, which the statute provides for, they'd all be in excess of $25,000 anyway. I frankly think the argument is a red herring. Thank you.
Okay. Mr. Ayer, rebuttal then?
Your Honor, that issue is actually decided in the Boyd case, which I referenced in my response to his motion. In that case, there were several plaintiffs, like in this one, that had a amount of controversy under the statutory limit. And in that case, the court opined that you cannot attach, one plaintiff cannot attach on the other plaintiff who has a higher threshold if it's not a class action. If this was a class action, you can rely and you can commingle and you can serve. But under Boyd, which is a published opinion, it's longstanding, and several cases have since relied on it. If in cases which is not a class action, plaintiffs that are under the threshold cannot piggyback onto plaintiffs who are over the threshold. And I cite that, Your Honor, in my response.
No, I get that. But these, even if they were under 25,000, each one of them was under 25,000, they'd be joined. I mean, I have that all the time. I have construction cases where there's foreclosure of a construction lien, which a circuit court has jurisdiction over, and count to breach of contract, and the breach of contract is for $6,500. It comes to me.
Yeah, Your Honor, you're right. So if they have one claim where it meets the jurisdictional threshold of the circuit courts, for example, in foreclosure, only a circuit court can foreclose. Then the circuit court, because it has jurisdiction over that foreclosure claim, then it has supplemental jurisdiction over the other claims. But in this case is different. There's no claim that in one of the 8 investors made that this court has subject matter jurisdiction of. Like there's no like equity claims, there's no foreclosure claims. They're all monetary claims. They're all under 25,000 or less. So there's not
the limited liability company.
Your Honor, there's no there's breach of contract, which again their investment was $25,000 or less. There's breach of fiduciary duty again. Their damages will be limited to their investment. So that's one of our arguments, and that we have.
The complaint alleges that it comes under the Michigan Limited Liability Company Act. Did you read the complaint?
Yes, Your Honor. I read the. Yes,
it alleges that. It even alleges that in the context of jurisdiction.
Yes,
okay.
Your Honor.
Do you want to respond to anything else in rebuttal?
Yes, I do. Thank you, Your Honor. First, Your Honor, I'll work my way backwards. In terms of filing the complaint on Wednesday, my firm was just retained on November 20th, about 6 business days ago. I actually personally delivered the motion to Mr. Insinsko so I could have a conversation with him. I also even called him to see if we can talk about it, and my call wasn't returned. I also hand delivered this response to his motion for entry of judgment. And again, I called him to see if you want to chat, left the voicemail, he didn't call back. We got no request to adjourn this hearing or anything like that. So for him to say that, we deliberately waited till the last day, we made substantive filings in, 6 business days, which we presented to the court. And by no means it was a way to, sandbag or anything like that, Your Honor. By no means. The affidavit of meritorious defense, I would leave that. It speaks for itself, Your Honor. It has tremendous facts in there, which details the numerous defenses, absolute defenses, which Mr. Ansel has. I understand, Your Honor, that perhaps the lack of subject matter jurisdiction, maybe we get more briefing on that or on a later date. That's not necessarily up. It's just one of many defenses that we have. It's not our sole defense by any means. And that's only limited to 8 of the plaintiffs. With respect to the affidavit never being signed and not attached to the complaint along with the contract, well, that's the very definition of lack of due process. When you don't attach an exhibit to your complaint, we have no way of making sure that that exhibit is what they say it is. We have obviously a copy of the operating agreement. We don't know what was attached to his complaint because he never served it. With respect to the affidavit that the complaint relies on, it was just signed 2 days ago. So again, it couldn't have been attached, and we couldn't have got it, which he now admits that we did not receive. With respect to opposing counsel's position on being able to sign his own default, the Supreme Court did say that only the clerk can sign a default. The SCAO form only authorizes the court clerk to sign a default. I've also polled a dozen attorneys to see their point of view, to see how they read it as well. And everyone speaks with one voice and saying, clearly, the clerk has to sign it, and that's the mechanism which it is entered. Your Honor, I didn't ask for sanctions in my motion to set aside a default because the plaintiff's counsel didn't put any authority that he's allowed to sign it, and submitted that a signed default, which he has no authority under the court rules to sign. As a proponent of civility among counsel, I didn't ask for it because that's just kind of the way I practice law. I also grant extensions routinely when opposing counsel, especially when it's adverse, they have to kind of, before they ask for a request, they kind of have to swallow their pride a little bit. And, they're asking for mercy, which is hard for, people to do. And so when I was a young attorney, when opposing counsel, asked for an extension, I called one of my mentors and I said, it's, tomorrow I can default them and they're asking for a couple week extension. And my mentor said, of course you grant it. Of course it benefits your client because it benefits the entire profession. We treat each other. Thank you, Your Honor.
All right, thank you. And I thought you were a rather young attorney, but still, but anyway.
Almost 15 years.
This motion to set aside the default, the defendant claims that there is good cause because of both a substantial defect or irregularity in the proceedings upon which the default was based, and there's a reasonable excuse for the default. There's of course a second part to the test, but I'll get to that in a moment. First of all, the defendant says that under this heading of substantial defect or irregularity in the proceedings, the defendant complains about not all the exhibits being attached to the complaint. I just think there are a myriad of reasons why that is not a substantial defect or irregularity. First of all, the court rule doesn't even require attachments except when the complaint is based on a written instrument. So I would suggest that the affidavit wasn't even required to be attached to the complaint. But second, the court rule has exceptions for instruments that are in the possession of the adverse party. Now, true, the rule says that you're supposed to say that in the complaint, but that's a very, very minor thing. The defendant had both the operating agreement that he signed and the affidavit in his possession. So that's the second reason why I think that just doesn't even come close. Third, the omission of the two documents that the defendant already had in his possession is not a substantial defect or irregularity, and that's what is required. At best, you can say that it's a minor and inconsequential defect. Fourth, it's not even a defect in the proceedings upon which the default was based. The way that an improper notice of the default would be, or improper service would be. This is wholly unrelated to proceedings upon which the default is based. This minor and inconsequential error cannot possibly rise to the level of a denial of due process, which is what the defendant claims that it is. And I would also add that none of the cases cited by the defendant stand for anything near the proposition that a default must be set aside if all the documents weren't attached to the complaint, or that somehow that invalidates service of the complaint. Just as an example, and I don't want to get too much into this, but the English Gardens condo case that the defendant cited to, that was the Court of Appeals saying this document wasn't provided to us by either party, so we're dismissing that claim without prejudice. That's the Court of Appeals saying we don't have the document to review the claim, so it's dismissed. And that was a similar thing to Atlanta International Insurance Company, where the Court of Appeals was just trying to figure out what's the plaintiff's position. Is the plaintiff claiming there was a written contract, or is the plaintiff claiming there was a verbal contract? And they were clearly grappling with that. And they said, well, the plaintiff, no one provided us with a written contract, so we're just gonna assume that it was an oral contract that the plaintiff is claiming. But there was no disposition of the case based on a contract not being provided. It was the Court of Appeals trying to figure out what the plaintiff's position was. So, I mean, those cases are almost cited in a way that's misleading, but they certainly don't support what the defendant is claiming is a substantial defect or irregularity. The second claim that the defendant makes is that Ms. McCluskey signed an acknowledgement of receipt and not an acknowledgement of service. The caption on page 1 calls it an acknowledgement of service. Not only that, Mr. Inocencio's transmittal letter on September 30th called it an acknowledgement of service. Furthermore, the complaint was served on September 30 of this year when Mr. Inocencio's office emailed it to Ms. McCluskey. Service is delivery, in my view. I know we're going by the October 20th date that I guess Ms. McCluskey wrote in or changed it to. But that summons and complaint, they were served on September 30th when Mr. Inocencio sent them to Ms. McCluskey. Now, she did write the date or change the date to October 20th, but either way, the default wasn't entered until November 12th. So you've either got some 43 days from September 30th, or you've got more than 21 days from October 20th. But either way, the service was validly made. The acknowledgement of service was signed, and there was no shortened period of time before which the default was entered. Then the third complaint by the defendant is that there's been no default signed or entered by the clerk. Signed / entered by the clerk is how the defendant puts it. I'm going by the court rules. And, you know, yes, I know here in Ingham County, which actually technically I'm sitting in Jackson County, but here in Ingham County, I see the scale form used, and I see the attorney filling out the top of it, and then the clerk enters the default. There's no requirement that that be done that way. I'm going by the court rule. The court rule says if a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend as provided by these rules, and that fact is verified in the manner prescribed by MCR and filed with the court in the request for default, the clerk must enter the default of that party. Here, the attorney did make the facts known as required to the clerk. He did an affidavit. He said more than 21 days have gone by. There's been no answer. And the clerk entered the default. The register of actions shows that the clerk entered the default. So I have to reject that argument as well. There is even something in here at one point, and it might be in the other motion or answer, I don't know, where the defendant even asserts that the complaint was not properly verified. But again, the court rules, MCR 1.109 D3, the complaint may be verified by the party or someone having knowledge of the facts or upon information, knowledge, and belief. So again, these are not valid issues. Mr. Walton's verification of the complaint complies with that. And then it is claimed that there is a reasonable excuse for the default. And for that, I have examined the affidavit of Rebecca McCluskey. She is a duly licensed attorney who's represented the defendant for 3 years prior to this lawsuit. And essentially, she makes the legal arguments that have already been made and rejected by this court. But then when we get to paragraphs 20, 21, 22, 23, and 24, she essentially tells what the problem was. And what she says is that other law firms were being contacted to secure co-counsel. She doesn't practice in this particular area. Due to unforeseen challenges related to COVID-19, coordinating meetings and conference calls to interview attorneys proved challenging. After interviewing several attorneys, they sought assistance from Bodman. And this is really the crux of it, she mistakenly understood her client's engagement with Bodman was finalized, and also mistakenly understood that Bodman requested and received additional time to answer or otherwise respond to the complaint. There was unforeseeable good faith confusion between my office and Bodman, which was further compounded by the COVID-19 pandemic. There is a difference between just making a mistake and showing good cause. If there weren't, then every motion to set aside default where someone made a mistake would have to be granted. And that's just not the case, because it takes more than just making a mistake. Good cause means that maybe you made a mistake, but there was a good, understandable reason why you made it. And I don't see that Ms. McCluskey gives any good, understandable reason. She said she made a mistake, that she misunderstood with Bodman. She mentions COVID, and I have to just address that briefly, because I have the greatest sympathy for all of us and how our lives have been upended and disrupted by the COVID pandemic. But she doesn't explain. I mean, she doesn't say I was ill. I would hope she wasn't, but she doesn't say I was ill. That would be a good reason. She just says because of the COVID pandemic. Well, with all due respect, telephones have worked during the shutdown, even during the worst of it. Emails have worked. Zoom has worked. The very fact that this case was mediated in July in the middle of COVID just shows that, it really is not a problem as far as communicating with people or getting things done. I ruled on umpteen motions for summary disposition all during COVID. Attorneys are communicating just fine. So, I just can't find that there's anything in this affidavit that really establishes a good reason for an understandable mistake. It's just a mistake. She's not only represented the defendant for 3 years, but she even represented him in this dispute pre-litigation and even went to mediation in July. And then to top it all off, when that mediation didn't work out, she wrote to the plaintiff's counsel about, I realize here I'm paraphrasing, but there's no option other than litigation. We're ready to proceed with litigation. We've known of the threat of litigation for some time now. So, it was known this was coming. It came. There were 43 days to contemplate it, and there's no reasonable explanation for the failure to answer. Ms. McCluskey's mistake, and I'm sorry for it, but it was a mistake unsupported by any justifiable or explainable or understandable reason. And so it just doesn't constitute good cause. And I would add, after all of these issues that I've addressed, that, I really think the defendant has no cause to complain about the plaintiff's brief, which they did, or anything else procedurally in this case, because the plaintiff's brief is not only non-conforming, and the defendant's brief, if I said plaintiff, excuse me, it's not only non-conforming, as plaintiff pointed out, and as I noticed before even the plaintiff pointed it out, with multiple pages of single-spaced paragraphs. But, you know, I have to say, honestly, it's both legally and factually unsupported. I'm not sanctioning anybody. As the plaintiff suggests, I'm not sanctioning the defendant. The defendant has enough problems. But one final example is the claim that the court has no jurisdiction because most of the defendants have money claims under $25,000. Well, the complaint alleges that the claims are over $25,000. The complaint alleges that there is jurisdiction under the Michigan Limited Liability Company Act. And, you know, we can fuss over, you know, the other defendants or plaintiffs besides Mr. Walton and what is their exact amount of money damages. But, you know, the end result is whether they belonged in district court or not, they would surely be joined with this claim by Mr. Walton that the court surely 100% has jurisdiction over under the Business or the Limited Liability Company Act. So, you know, the law is that the good cause and meritorious defense are two separate things entirely. If you don't make good cause, you can't make up for it with a meritorious defense argument. I find it, there's some argument about whether that's 100% true because there's those cases that say, well, you know, maybe if there's something really meritorious, then it would take less good cause. So, you know, I have examined the meritorious defense part of this issue. I don't think that there's, I do think this case is far, far away from good cause. So, you know, I really think there's a solid ground not to even go on to meritorious defense. But I do agree with the plaintiff that the affidavit of meritorious defense, you know, it's not based on the number of paragraphs you can put in there. It's based on what is in the affidavit of meritorious defense. And there are just a lot of conclusory statements. The whole thing almost is conclusory statements, denying responsibility. And then there's even false statements based on the defendant's own prior statement to investors stating that Mr. Walton never signed the funding agreement. But it also contains no evidence, and that is the affidavit of meritorious defense contains no evidence that grounds for summary disposition exist. It only states conclusions. And to the extent that, you know, some of these things that are in the brief about, well, there are insufficient facts alleged, I'm not sure that really rises to the level of a meritorious defense. Insufficient facts alleged are often cured by amending the complaint, like with fraud, where it's not, you know, fully set forth exactly what the specific requirements are under the court rule. They're fixed by amending the complaint, but that doesn't really go to the merits of the claim and say that you don't have one. And it doesn't matter anyway, because the affidavit just makes these conclusory statements. And I do accept the plaintiff's argument that if there's any doubt, the answer that shouldn't have been accepted, and if filings had been done through Ingham County, which I believe they're not, they're being done through Jackson County. Through Ingham County, our practices, our clerks, I don't think would have accepted it for filing. But in any event, the answer demonstrates it, because the answer just denies, and it doesn't even comply. So the affidavit of meritorious defense doesn't get us there either. All of that said, I am not granting the motion to set aside the default. The default was properly entered. But there is the request to enter a default judgment now. And the court rule does say that if, in order for the court to enter a default judgment or to carry it into effect, it is necessary to take an account, determine the amount of damages, establish the truth of an allegation by evidence, or investigate any other matter. The court may conduct hearings or order references it deems necessary and proper, and shall accord a right of trial by jury to the parties to the extent required by the Constitution. The motion for entry of default judgment it doesn't give me any basis for understanding or concluding what those damages are. It just says these are the damages, and it does list them, it itemizes them, but how do we get there? I can't sign a judgment with damages in it. I can sign a judgment as to liability because I'm not setting aside the default, but I can't sign a judgment on damages unless I have something that allows me to determine the amount of damages and what they're based on. So we do have to have further proceedings in order to get there. So I mean, that's my ruling, and I am ordering that the answer affirmative defense's counterclaim be stricken as improperly filed. Do you want to do an order, Mr. Inocencio?
I will, Your Honor, thank you. And I will submit that to opposing counsel for their review and consideration. So hopefully we can reach an agreement on the contents of that order and form prior to having to submit it under the 7-day rule.
Okay, thank you. That'll conclude our hearing then.
Thank you, Your Honor. Have a good day, everybody.